Can you admit participants in the meeting?
Yes, I'm doing that.
It's already almost 10 minutes, so shall we start?
Yes, ma'am. Yes, ma'am. Okay. Good afternoon to all of you. I'm hoping that my voice is audible to everyone. Okay. Okay. My name is Vaibhav Singh Mishra. I'm founder and publisher at Arbitrators. For the time being, I'm acting as an advocate at Lucknow High Court, judicature of Allahabad High Court, and serving as a junior law trainee at AGF's Student Judge Office. We are, on the other hand, also having our honorable speaker, Dr. Komal, Dean PG Professor of Law in IILM Law School and IILM University, Gurgaon. I'm hoping that you all have very known with the contents of our honorable speaker in the very brochure. On the other hand, we are also having Mr. Varun Kumar. He is a practicing at on Himachal Pradesh and district and high court level as well, and founder and publisher at the same law audience as well. So today's our topic is all about mastering dispute resolution, how to become an arbitrator in India, step-by-step guide to a credential and training. The agenda of today's webinar is to understanding the very nature of the arbitration in India and how to become arbitrator in India, what are the future prospects of the arbitrator, and so on and so forth. Now, ma'am, you can take this moment from your side, and we can start from our webinar.
So am I audible?
Yes, ma'am.
So, good afternoon, each and everyone, ladies and gentlemen, esteemed the journal members and aspiring arbitrators. So I'm truly delighted to stand before you today to discuss a path that I am somewhat passionate about, pursuing a career as an arbitrator. So arbitration, often referred to as the art of dispute resolution, which is a field that offers immense opportunities for those who are committed to solving conflicts outside the courtroom. So whether you are a legal professional looking to expand your horizon or a newcomer who is intrigued by the world of alternative dispute resolution, this workshop aims to provide you with the roadmap to navigate your way into this fulfilling profession. So what we understand as an arbitrator, arbitration or arbitrator. So let's start with that. This is a commercial arbitration and some recent trends. PPT, can you put the first slide? The next one.
Yes.
This one?
Can you change the slide, please?
Which one, ma'am? Arbitration in India?
Yes,
Okay.
next. Yes, arbitration in India. So what is arbitration and why do we need the arbitration and how is it different?
Second PPT.
It's okay. So what is the arbitration first and why do we need? And third thing is, how is it different from the court proceedings? So whenever you want to be an arbitrator in India, you need to understand कि arbitration है क्या चीज़? What is the arbitration means for? So arbitration, when we talk about basically, is a form of alternative dispute resolution. So for dispute resolution, there is court. for alternative dispute resolution, there are ADR methods, which enjoy significant advantages such as lower cost, greater flexibility of the process, higher confidentiality, greater likelihood of settlement, choices of forum, choices of solutions, etc. So, having said, one of the most popular, widely recognized and practiced form of ADR is arbitration. So there are other methods also, mediation, conciliation, and so on. But arbitration is the most recognized and practiced form because of these benefits which I mentioned, that lower cost, flexibility, confidentiality, and settlement ki chances are so high. So arbitration law in India has always been trending since the inception, which was in 1940. So the present date arbitration law is a formation of several promulgation ordinances passed by the government of India to meet the economic reforms taking place in the country from time to time. Arbitration law in India is primarily contained in the Act of 1996, an act which was passed to consolidate the laws relating to domestic as well as international arbitration and its enforcement. So this is an attempt to make arbitration a preferred mode of settlement for commercial disputes, and India is making a hub for international commercial arbitration too, because of some recent amendments in 2015 and 19. So the current law is a composition of several such amendments, with the latest amendment which was introduced in 2019. So arbitration is nowadays very much famous. So we are getting so many students as such into ADR specialization. So that's also one of the we can say the indication that arbitration is nowadays very much famous. So the law is a choice upon the parties to enter into commercial transaction, which are knowing well that in case of a dispute, so they can refer their dispute to this simple, quick, convenient, and cost-effective method, uh, apart from the tedious and complicated procedures into the court. So Act covers both domestic as well as international arbitration. So especially we are discussing about that. So arbitration, what is arbitration? That I already mentioned, that's a process between two of the parties, and they can appoint the third arbitrator, and so to solve their disputes. So what are the objectives of the arbitration? Can we come up to the next slide? Next slide, please.
Yes, ma'am.
Objectives.
Yes, ma'am. I share the. Are you able to
Third
see?
one.
So yes, sir. So arbitration is a good career option that can offer a range of benefits apart from the objectives of the arbitration. So the objective of the arbitration as such, because this cover both international and domestic arbitration as well as conciliation. And further, to make the provision for an arbitral procedure which is fair, efficient, and capable of meeting the needs of the arbitration. Arbitration always permit an arbitral tribunal to use mediation conciliation so that settlement of dispute can be happen, and that too quick, and to provide that a settlement reached by the parties as a result of conciliation proceeding will have the same status which is of an arbitral award, because वो उतना ही effective होता है जितना कि एक normal award होता है. So this also provide that an arbitral tribunal gives reason for arbitral award, and it provided every arbitral award is enforced in the same manner as a decree of the court. So efficacy remains the same, but this is a quick and immediate method. So that's why these are the some objectives of the arbitration. So these are the reason by which every or most of the parties go for arbitration. And why we opt for parallelly, I'm telling you why this is a good career option. So opting for a career in arbitration can offer a range of benefits. So we will be discussing that also soon. So come to the next slide, please.
Yes, ma'am. Share. The arbitration process.
Yes, this is the arbitration process? So these are the 3 steps for arbitration. First is the submission for the dispute, second of the hearing, and third is the award. Right, so let me explain to that. So normally an arbitration agreement, that is with the few things, some of the key elements should be contained in the arbitration agreement. When you have that agreement, then you can go for the hearing and other methods. So first one is the consent. So an arbitration cannot happen without the consent of the parties. So consent is contained within an arbitration agreement. An agreement clearly specifies the desire of the parties so that they may go for the to arbitrate their disputes. In other words, they clearly note that the event of a dispute between them would not go to the court. Instead, they will proceed to arbitrate their disputes. So this agreement takes the form of a binding contract, and as per Section 7 of the Act. So agreement means an agreement within the parties to submit an arbitration all to certain disputes which have arisen or may arise between them in respect to a defined legal relationship. Second, what they can go, there should be a presiding authority. So the authority who is adjudicating the dispute is better known as the arbitral tribunal. So it is similar to the judge that preside over the court of the law. So presiding authority is known as the arbitrator, who is in charge of deciding the dispute between the parties. So just like the judge, an arbitrator also have several responsibilities set out in the code. So arbitrator is under oath to perform its duties, and he or she is bound to take decision and conduct the proceedings in a neutral and impartial manner. So one of the key features of an arbitration agreement is the fact that parties are free to choose their presiding authority. So this legislative clause not only inspires confidence in the arbitrators, but also the process and the decisions taken as forward. So seat of the arbitration is again a key element of the arbitration agreement. So seat of the arbitration determine the court which would exercise jurisdiction over the arbitration proceedings. So in absence to such agreement, so the 96 Act solely operates within the territory of India. Then party autonomy and the procedure. So arbitration gives the parties to choose the select applicable laws, especially if the arbitration is an international commercial arbitration. So additionally, there is an enormous flexibility to choose the procedure that shall be applicable, and rules of the arbitration can be self-governed. However, the said rules have to be in the spirit of public interest of India. Finally, the outcome. So no appeal lies against an arbitral award. However, if the arbitral award can only be set aside or suffers from an invalid arbitration agreement, so party have the incapacity to enter into an agreement or independence or impartiality or unfair procedure, then only you can appeal. Otherwise you cannot appeal, and this is the final order from the arbitral award, right? So if we go by the procedure, so after this agreement, the consent should be there, the other all elements, you can submit to the dispute to an arbitrator. Then the hearing will be there according to the fair justice system and all. And then the final award of the arbitrator has happened. So next slide, please.
Yes, ma'am, share.
So this is the process of arbitration. Then again, I'm repeating, the case file need to be there. Arbitration selection process, where you need the arbitration. Preliminary and scheduled order should be there. Then all the process according to the principles of natural justice. Then hearing is there according to the, or mediation is there in between the both of the parties in front of the arbitrator. Arbitration go for the hearing, and then post benefit, and then award is there. Next slide, please.
Yes, ma'am, share.
Next, appointment of an arbitrator. So appointment of the arbitrator need to be decided by the parties mutually or by the court. And finally, if court is there, court is the deciding authority. So Supreme Court the international commercial arbitration. In case of international commercial arbitration, the Supreme Court is the final authority, and in case of domestic arbitration, High Court is the authority who can decide the arbitrator appointment. So otherwise, parties mutually can go for the appointment of arbitrator. And I just want to brief you one thing. According to some judgments, the Mother Boon Private Foods Private Limited versus Mindscape One Marketing, the court held that the arbitration agreement has to be in writing. Since the arbitration clause, which is a part of the contract, was in writing, the same could not have been superseded by any oral demand or agreement. And further, I want to discuss one more case in which Supreme Court of India is referred to the attributes or essential elements of an arbitration agreement, that has held that if an agreement to refer disputes or differences is expressly or impliedly spelled out from the clause, so this everything should be in the agreement. So that's why the key elements of any arbitration procedures are very much relevant, and the agreement is very much relevant. Why I want to brief you about this thing? Because arbitration is that thing, and the relevancy of arbitration agreement is so important. That's why we can discuss about the role of the arbitrator. That is quite necessary and relevant. So there have been recent moves to improve the arbitration landscape in India. Significantly, amendments to the Arbitration Act have sought to improve speed and efficiency of arbitration because of imposing time limits, because nowadays every dispute need to be settled within time. So arbitration is a key method to resolve the dispute, encouraging institutional arbitration. Nowadays, because of courts are so burdensome, they encourage institutional arbitration. Reducing the scope of court intervention both at the pre-arbitration or post-arbitration stage. This is required, and these are the things the courts and the judicial decisions are going up with. The reducing the scope of lesser and lesser court intervention is taking place. They discourage filing frivolous applications which are challenging arbitral awards. They also discourage delays by introducing a more realistic post regime. And because as I discussed, the advantages of commercial arbitration also, the freedom of parties and ability to parties to appoint arbitrator, because they can choose their arbitrator as such. So this is also advantage. Because of that, the importance of arbitrators are booming up, right? So can you come up with the next slide? This is who can be an arbitrator. Now this is the key element. I was just introducing the topic as such now till this moment. So who can be an arbitrator? Let's come to that point. So arbitrator kaun hai according to you? Is anybody can brief us among the audience? Who can be an arbitrator? In the message.
Is there anyone who wanted to express their opinion who can be an arbitrator in India? Any simple answer, any layman answer would be great for us.
You can raise your hand or you can unmute yourself. Yes, ma'am.
Yeah.
Mehul. Yes, Mehul.
Good evening, ma'am.
Mehul Narayan.
Hello, am I audible?
Yes, Mehul.
Good evening, ma'am. My name is Mehul Dubey.
Mm-hmm.
So, ma'am, an arbitrator is basically a neutral third party that oversees the ADR mechanism, as you mentioned. He is basically governed wholly by the Federal Arbitration Act.
It's okay. Let's come to that point. Varunji, can you play the second slide? Next slide. Because there is the explanation of the arbitrator. So, arbitrator. So first we need to understand whether you are whether with the legal professional you are. If you are looking to expand your horizon, or a newcomer who is intrigued by the world of alternative dispute resolution, So this workshop aims to provide you with the roadmap to navigate your ways into fulfilling profession. So first thing first, to embark your journey as to understand the role of an arbitrator, it is essential to understand the role. So arbitrators are obviously the neutral third parties who are there to resolve disputes, but amicably. They listen to the both sides, evaluate the evidences, make the binding decisions, and to succeed, you must embrace impartiality. They need to be fair and with a commitment to upholding the rule of law. So basically, arbitrator obviously he is a neutral party. ठीक है, and उसकी the main duty is to resolve the dispute, but dispute with amicable settlement. Amicable कब कहते हैं? When both parties are agree to that settlement, and so that he need to listen to the both sides, he need to evaluate the evidences and make the decision which is binding on both the parties, right? And for that he need to embrace the impartiality. ये एक qualities होती हैं एक arbitrator की. He need to be impartial, he need to be fairness, but on the balance side he need to uphold the rule of law. So this is the role of an arbitrator. ये बहुत बेसिक क्वालिटीज है, राइट? बेसिक बट इनहेरेंट क्वालिटीज हैं विच यू कैन नॉट वायलेट. अगर आर्बिट्रेटर इम्पार्शल हो जाएगा या पार्शल हो जाएगा तो जो ऑथेंटिसिटी है, जो कोर एक रिक्वायरमेंट है आर्बिट्रेटर की, वो नहीं रहेगी. सेकेंड थिंग, एजुकेशनल फाउंडेशन. So he need to hold a educational foundation which is very much crucial. While it's not mandatory, a bachelor's degree in law, business, or any field related to the field, any field is beneficial. So many arbitrators have a legal background, so that जो juris doctor है, degree for an added advantage हो जाती है, but as such now अभी तक कोई mandatory requirement नहीं है. But a strong educational foundation is very much crucial to that. Then specialized knowledge and training. So arbitration requires specialized knowledge in the areas such as contract law, labor law, international law, depending on your focus. So enroll in arbitration training programs such as those offered by some respected organization like within India there are a chartered institution of arbitrators. We will not name as such institution, but there are some institutions who are giving some courses reference to that. So earning certification enhances your credibility and open the doors for your career, right? Otherwise, as such, there is no specialized degree required, but areas such as contract law, labor law, international law, because if you go for international commercial arbitration, holding a degree of international law is required for your knowledge per se. If you are dealing with the domestic arbitration, basic contract is necessary. It's not like specialized knowledge into the field, which is not mandatory, but added advantage. So specialized knowledge and training will be obviously helpful. Then building practical experience. So practical experiences is invaluable. So you can seek internships or volunteer opportunities with established arbitrators, law firms, or ADR organization. They can give you hands-on experience which can by which you can hone your skills and build your network. So further, the next thing is networking. Am I audible?
Yes,
It's
ma'am.
going smooth? Okay, thank you. So networking, another way, building relationship in the arbitration community is relevant and essential. So attend conferences, seminars, workshops, engage in the conversations, ask questions, seek mentorship. So networking can lead to valuable opportunities. Then establish your reputation. Begin with the smaller cases to build your reputation and confidence. So with reputation, obviously your confidence will be the added advantage for this field of interest, and your reputation as a fair and skilled arbitrator is most valuable asset for long term. So with time and experience, you can handle more complex cases. Initially, obviously, it will take time, and next is the joint professional organizations, as I already suggested. So taking the some organization certification, that is not mandatory as such, but obviously will be an added advantage. So the provide it will always provide access to the resources, continuing education and networking opportunities. So above whatsoever I mentioned, that networking, reputation and practical experiences, especially knowledge and training. So any professional organization will be an advantage to your field of interest and area. Market yourself, create a professional online presence via websites, LinkedIn profiles, showcase your qualification, expertise and successful case outcomes. So अगर आपने कोई केस में arbitrator की तरह काम किया है initially, showcase the same. LinkedIn profiles are really helpful to build your presence in the professional area. So adhere to the ethical standards, maintain a highest ethical standards, impartiality, integrity, confidentiality, because all the parties are just looking up to you because of these things. So these are non-negotiable in this profession. Then the continuous learning, obviously, that I have put because the field of arbitration is dynamic. So stay updated with legal developments and industry trends through reading, attending seminars, or further your pursuing further education into your field of interest. You can take some certificate courses which are online. You can attend maximum of the workshops as such, because with every workshop or with every seminar or with every attendance of your into this field will give you added advantage, will add a feather in your cap. So in conclusion, pursuing a career in arbitration is very noble endeavor. It allows you to help individuals as well as organization and give a peaceful resolution in their disputes. So obviously in this field of interest, it will take time and dedication. So you can take the opportunities to learn, grow and build your reputation as a trusted arbitrator. So this is obviously with the arbitration career is holding a range of benefits, both professionally as well as personally. So in the next slide, we will be giving you the advantages of pursuing a career in this arbitration field. Next slide, please. Next, this we covered.
Just a moment.
Yes, this one. So with maybe this question came up in the minds of audience, that why to choose this field. So arbitration is obviously a growing field. There is a constant demand for skilled arbitrators. This means ample career opportunities whether you choose to work independently or with any law firm or ADR organizations or within the corporations. So there are endless career opportunities with the time frame as such. The dispute resolution system and mechanism, people are taking option for arbitrators only. So with this thing, obviously this is a good career options. Then flexibility, arbitrators often have more control over their work schedules compared to the traditional courtroom lawyers. So this flexibility can lead to a better work life balance. And nowadays people are choosing these kind of work options in which the flexibility is there. So as an arbitrator, you have diverse specialization offers opportunities. So arbitration covers a wide range of industries and areas of law, including commercial law, labor law, construction law, international law and family law. So you can specialize in any one area or more, and that aligns with your interest or expertise. तो जहाँ आपको लगता है कि you are very good into the family matters, so you can go for that specialization and that field only. If you think that commercial law attracts you, so you can choose such options in which the arbitration in commercial law is dealing with. You can choose for labor law options also. So high earning potential is also there. So experienced arbitrators can earn substantial income, especially for complex cases and those involving high stakes. So your earning potential often increases with your reputation and experience. So this is the one thing in which if you put more hard work, you can earn more. So this is totally dependent on you. So if you go for more certifications and if you have more fan following in the sense if you have more good reputation into the field, so obviously you can earn more. So there are alternative to litigation also. So litigating lawyers, arbitration offers party an alternative to cost and time consuming litigation. So this is more attractive option for business and individuals who are seeking efficient dispute resolution, right? So if you have problem solving skills, so arbitrators develop strong problem solving skills, negotiation and mediation skill, which can be valuable in various aspects of life as well. So not just professionally, this the career opportunity help you in personal life also. So arbitrators को international opportunities भी हैं. So arbitration cases can have an international dimension if you are interested in working on a global scale. So international arbitration can provide exciting opportunities to you. So in fact, arbitrators obviously stay updated and legal developments with legal developments. So obviously a continuous learning का जिसको शौक है, you can choose this career option. And parallelly, when I discuss the personal benefits and personal benefits as such to your personality, professional benefits, this is the first priority for everyone. But the third one, which is some people are least bothered about, that is contribution to the society. So with solving the disputes in a peaceful manner and quick manner, so your work can have a positive impact on individuals, business, as well as society as a whole. So, and whosoever love for networking and interacting with the professionals of diverse background, so obviously this is a good career options for you. So I discussed many of the things, and otherwise
Do I need to share any other slide? Or we are open for questions.
any queries as such अभी कुछ हैं किसी को तो we can take those queries. नहीं अभी आगे नहीं जाना.
Okay.
This is not over. We
Okay,
have
no
to
issue.
discuss how to go. Till now we discussed about the arbitrators ke benefits, and we will discuss about the certification, how to become an arbitrator. First, if there are some queries or concern, we can take in between.
Yes, Siraj Krishna, if you have any query, you can ask. You have raised your hand.
Hi, good evening, ma'am. Am I audible?
Yes, you are audible. Tell me.
Ma'am, yeah, I want to know the difference between arbitration, mediation, and conciliation. Thank you.
Anything else? Anyone else?
So, ma'am, you can continue. I guess we can take the queries at the end of the session.
Okay, no problem. Yes. But hello,
Yes, ma'am.
audible now?
Yes, ma'am. You're audible.
Yeah. Coming to that concern, so there are some differences between mediation and conciliation as such. So mediation is a mediator who is facilitate a conversation between the parties, and while the conciliation, it intervenes the conversation to offer the solutions. So there is a slight difference between a mediation and conciliation and arbitrator. So we are discussing here the arbitration part, because this is the official arbitration agreement in which both the parties choose the arbitrator and go for voluntary thing out of the court settlement. So we'll come later to this. Before that, let me conclude to the matter which we were discussing. Right. Let's come to the next slides, please. So this is about the eligibility, training, assessment, and accreditation, right? So this is the most important part in which we need to discuss how to become a arbitrator. So just a minute. So this thing, let's come to the point. As you embark the journey in the world of arbitration, so as I already encouraged you and briefed you about the benefits and why to choose this career option, so one need to be passionate, ethical, and persistent. So your commitment to justice and conflict resolution will not only shape your career but also contribute to a more harmonious society. So becoming an arbitrator involves a combination of education, training, and accreditation. So arbitration is a specialized field, as we discussed, and being a qualified arbitrator requires specific skill and knowledge. Not this is not everyone's cup of tea. So there is a step-by-step information to how to become an arbitrator and obtain accreditation and training. The first thing first, the educational background, right? So eligibility. If we discuss about the eligibility, so educational background is relevant. So start with the strong educational foundation. You can join or work as an arbitrator from you can be from any of the field. So while there is no strict educational requirement to become an arbitrator, so having a background in law, business or related field can be advantageous, because आपको law पता होगा, laws पता होंगे, तो this will be really effective in your profession. So arbitrator could be from the any of the field. He could be a law graduate or BBA हो सकता है, BCom हो सकता है, because there is no such bar to appoint to work as an arbitrator. But you need to know and you need to have a sound knowledge of your area. So because arbitrator suit करता है in the field of law, हम किस लिए कहते हैं, because this is a option to the court, right? Judicial जो आपके courts होते हैं उसका एक option होता है. So उसके पास क्यों आ रहा है, because this is an option. अगर आप court room में नहीं जाना चाहते हो, you want to go for an arbitrator, so obviously having a background in law, business or related field is really advantageous. So you can gain relevant experience, so acquire practical experience in areas related to arbitration or dispute resolution. So working in law firms, corporate legal department or as a mediator can be beneficial. So अगर आपका कोई experience है with this field of this thing, so arbitration का experience है, dispute resolution mechanism का experience है, legal department में अगर आपने काम किया है, और a mediator, so this is always a benefit. So specialized in a field, so choose a specialized area of specialization for your arbitration practice, such as commercial, construction, labor or international arbitration. So your expertise in a particular field can make you sought after arbitrator. So arbitration training की अगर हम बात करते हैं, for enrollment into any arbitration training programs or courses, so many reputable organizations and institutions, they offer arbitration training, which includes the Chartered Institute of Arbitrators. So they offer training and accreditation program at various levels, including associate, member, or fellow. So if you look at the American Arbitration Association is also an example. Comprehensive training programs and resources they offer for arbitrators. So again, the international commercial dispute resolution. ICDR. This is a division of AAA. They offers training and accreditation program with an international focus. One can go for that. These are the training programs you can do. Local arbitration centers are also there. Many countries have local arbitration centers that offer training programs. So like India mein Indian Council of Arbitration hai. They provides training in India. So further, if now we talk about the assessment and accreditation. So accreditation means you can seek accreditation from reputable arbitration institution. Accreditation helps to establish your credibility as an arbitrator. So this process also vary depending on your organization, but it generally includes application. उसमें करना क्या? You need to submit an application to the relevant arbitration institution. You can specify your qualification and experience into that. Further, the second process is the assessment, second stage of the process, accreditation key. First is to submit an application, then you need to give the assessment. Some institution may require you to pass an assessment or examination to demonstrate your knowledge of arbitration principles and procedures. So further experience, so you have to show your practical experience of certificate or legal professional का एक experience certificate देना पड़ता है to show your evidences that you are practically experienced as an arbitrator. Further, the recommendations, they ask for the to provide references or recommendation from experienced arbitrators or professional in the field. They agree to abide by the institution code of ethics and professional standards. So आपको वो sign करना पड़ेगा that you agree by the institution code and ethics of professional standard. So this is it for the this thing, the accreditation. So I discuss about the eligibility जहाँ पे दी नहीं हुई है, but training you can take. You can submit your assessment, and accreditation you can take from any of the organization if you wish. Right? Next slide, please.
Yes, ma'am.
So
Sure.
these are the benefits. So if you go for the that we already discussed कि क्या क्या benefits हैं to being an arbitrator, obviously that personal benefits are also there and professional benefits are also there. So financial तो obviously हो जाएंगे. So these are the benefits. Obviously the greater exposure and growth options are there because बहुत requirement and need है आजकल market में for arbitrators. The way the industry is going, the way the people are going and out of court settlement को लोग prefer कर रहे हैं, so obviously there are certain benefits. So obviously your knowledge, skills and awareness and networking opportunities enhance after becoming an arbitrator, and after a certain experience obviously you must be in demand, right? So basically come to the question. A question आया था about the difference between arbitration, mediation and conciliation. So arbitration is governed by the legislation and by the agreement between the parties. So an arbitration and conciliation act जो है वो govern करता है for arbitration. Mediation में there is no specific legislation as such for mediation, and there is no agreement required for going for the mediation. Only high court rules are there for an mediation mechanism. For conciliation, obviously because यहाँ पे arbitration के अंदर there are two parties and arbitrator, and एक arbitrator आपकी choice का होता है and one is the neutral person. So conciliation के अंदर only one person is there, and conciliator by settlement dispute is a settlement agreement भी होता है. Conciliation proceedings obviously act के अंदर there are they talk about arbitration and conciliation act, but यहाँ पे settlement agreement होता है, award नहीं होता है, which is there in the arbitration. Arbitration में the arbitrator they announce the award, and award is binding for both the parties. And this is all that I need to brief you about this thing. Thank you for your attention, and I wish you all the best on your path to becoming skilled and respected arbitrators.
Ma'am, I would like to add some other points with the arbitration point. May I?
Thank you. Yeah.
In the today's session, we have discovered very fundamental nature of the arbitration and how you can become arbitrator, and the upcoming life once you opted yourself as an arbitrator. if we talk about arbitration, arbitration can be traced from the before the independence of the India in 1947. हमारे इंडिया में सबसे पहले पंचायती राज सिस्टम था। पंचायती राज सिस्टम से जो एक नेगोशिएशन, बातचीत करके मसलों को सॉर्ट करना, एंड द पंचायत leader one who gonna arbitrate matter and make a resolution upon the matrimonial matter and criminal matter and so on and so forth. But gradually, in the our Indian ecosystem, in the our Indian eco-legal system, people are often indulge in the litigation that is very vast. It takes a number of decades. But gradually, our corporate ecosystem and even our governments and criminal matters such as criminal matter which is come under the ambit of the CRPC 320, the punishment must be within the ambit of the 3 years and not a life imprisonment. You all can arbitrate, negotiate, and conciliate that matter outside from the court, as our ma'am has mentioned the amicable resolution. Amicable means that you all can short your matter even without approaching to the court. You can short your matter in your private rooms with the parties, with the concerned parties, and so on and so forth. In India, the arbitration and conciliation and negotiation is emerging opportunity for everyone. Every sects, every corporate company, even our state government, our central government also seeking the arbitration. In India, Arbitration and Conciliation Act is already going on, and number of the alien countries have also anticipated in the same arbitration act, so that they can short their matter on a basis of negotiation and arbitration. On the other hand, they do not want to approach the court of law, so that they can invest a large amount of money in the litigation. Thereafter, it takes decades and then get the justice upon the concerned topic. So there is no meaning of doing that. The prima facie arbitration, negotiation, conciliation would be sufficient and would be emerging future for everyone. Thank you all for your cooperation and joining the current session. You will get the webinar certificate by as soon as possible. That could be possible by us and by our team. It takes, as far as I know, it takes only 24 hours. Within 24 hours, you all get the webinar certificates. Okay. So if there is any doubts and questions in your mind, that you can ask to our mentor.
I guess Mehul
Kumar,
has
ma'am.
one question. Mehul, you can unmute your mic and ask from the speaker.
Yes, sir. So I have a few doubts with respect to the today's session from ma'am.
Yes, please ask.
So hello. Yes, sir. So my first question is with respect to the seat of the arbitration. Let's say if one of the party from the arbitration is from Jaipur and other is from Kolkata, and they have not specified in the agreement about their seat of arbitration, then sir, how will the seat of arbitration be decided?
Hello. So that need to be decided by the mutual consent.
Yes, ma'am. Okay. Ma'am, I have another doubt. In the slide process of arbitration, you mentioned preliminary and scheduled order. So, ma'am, what does that mean? Can you please elaborate?
And you are talking about, because there is no preliminary. Okay, that was all about. Let me come to that point. That was related to the orders only. That process. That was
Yes,
process
ma'am.
of
And
arbitration. In the selection process, preliminary. In fact, this is kind of uh, before the final award. If there is some requirement, right, there is any requirement of preliminary order, initial orders, interim orders. So that is like that only.
okay, ma'am. Ma'am, in the
That's why
same
I
slide you
mentioned.
mentioned.
That's why
Yes,
I
ma'am.
mentioned the brief knowledge about the maybe of the law, maybe of the business, that is required. The contract act. So this is required. That's why they are not saying that it's mandatory for any educational background, but this is required just because you can be a good arbitrator, which these with this quality.
Yes, ma'am. Ma'am, in the same slide, you mentioned about post-arbitration benefit. Ma'am, how is it different from final arbitration award?
Sorry?
Ma'am, in the same slide, you mentioned about the post-arbitration benefit, second last point, and ma'am, final arbitration award. So, ma'am, how are they different from each other?
हाँ, this is all about because मैं एक बार अपनी स्लाइड चला रही थी. So post arbitration award होता है arbitration hearing के बाद जहाँ पे लगता है कि there is as such कि your final award is going to be done, right? So उसके benefits क्या आपको advantages मिल सकती हैं before discussion, before announcement of final arbitral award. So final arbitration award के पास जैसे हमने बताया कि there is no appeal could be light, right? So post arbitration award is all about the benefits. There is a difference between the word post arbitration benefit and final arbitration award. So award is final and binding, but benefits are not binding. You can discuss upon that, then only the final arbitration award will be announced.
Okay, ma'am. Ma'am, I got my last question.
Yeah.
Ma'am, you mentioned somewhere in the slides about institutional arbitration.
Yes.
Can you please explain what it is and how, what is ad hoc arbitration also?
Again, institutional award की जहाँ पे बात होती है, this is related to international commercial arbitration, but as such it will take much of the time. So today we want to discuss about the how to become an arbitrator and as such. So you can send your questions or queries, so we can send you the replies.
That could be very
Surely, ma'am. Thank you so much.
answer for you, ma'am.
Otherwise we keep on discussing about this thing because otherwise अगर आप law में देखें तो there is like a whole lot of big chapter about institutional commercial arbitration and institutional arbitrations, right? So but this is related to international arbitration.
Okay, is there any other questions? Okay, I'm hoping that ma'am have encountered every question. So this is time to sum up the meeting. Thank you all for your cooperation and thank you for joining the today's session. Today's session was tremendous to know the very preamble and very fundamental about the arbitration, conciliation, and negotiation. And thank you so much for your time, ma'am. Thank you so much, Varun Kumar. Thanks to all. Let's sum up the meeting.
Thank you. Thank
Thank
you
you.
everyone.
Thank you.